Hear ye, hear ye, hear ye. All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near, give your attendance, and shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated. My name will make sure your cell phones are off and put away.
22-117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lally for the Commonwealth.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, so to start, I'm going to start with the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions. So after review of the pleadings, it's clear to me that the issues that give rise to the dispute do not invoke the gatekeeper function of the court. To me, it's rather a difference of opinions that need to be resolved by the jury. So I'm denying your motion. I'm not going to exclude the evidence. All right.
Excellent. Yes, that's a huge win for the Karen Reed defense team and for Karen Reed and for Richard Green. Holy crap. Like he was the data forensic expert. Like I said in the previous videos, he was the only data forensic expert to actually do his job, to actually rely on the hash values, and to use multiple software programs, multiple tools in order to verify those cell phone extractions, and he used the most recent versions of those tools. Like Richard Green's affidavit could not have been more thorough, I am so glad Hank Brennan lost.
So then I think what I'd like to move to is the defendant's motion to recover expert-related expenses from the Commonwealth. I did get a response from the Commonwealth on this, so I need to hear, Mr. Jackson, what it is you're asking me to do and why.
The court did receive the addendum filing the court asked for as well, correct?
No, because I've been waiting for it and I do not have it, and I checked as recently as 5 o'clock yesterday and this morning.
I'll get it.
Okay. Do you have an extra copy if you want me? Because I don't.
It was coming from, the final copy was coming from Ms. Little from back in my office. That was.
When did she send it?
When? Yesterday. I think I was on the plane.
Margaret checked for me yesterday.
I think it was yesterday. I think it was really due. I remember.
Can you come here for 1 second, please? To save me time, does your expert in his affidavit say that this information was erased or that it wasn't there?
Wasn't there.
Okay.
It was erased by an operation of automation.
But do I bother reading your expert's affidavit again so it's not in there?
And I'll address what
All
our
right.
concerns are in my oral statement.
All right. I'll hear you.
May I?
Yes.
The court started by asking what is it that the defense is asking for. Basically, we're asking to be treated equitably and fairly. This really is an issue of equity, an issue of fairness. And the court maintains this court maintains the inherent authority to issue sanctions when there is an injustice. And those sanctions can include something like cost-shifting sanctions. And there's a body of law that exists that deals with this exact thing. And that body of law includes the case of the Committee for Public Counsel Services versus the Attorney General. That's at 480 Mass 700. It's a 2018 case. The court may remember what was, I think, pretty widely known here in these parts, which was the Amherst scandal. Had a bunch of cases going back from 2010 all the way through.
I'm very familiar with the case.
All the way through 2018, and it culminated with Justice Gaziano discussing in his opinion, single justice opinion, exactly these types of things. And what Justice Gaziano said held was, quote, the Attorney General does not dispute that the court has the authority pursuant to Rule 14, sub C, sub 1, to impose remedial monetary sanctions for a discovery violation. And he cites Commonwealth v. Firth, indicating that sanctions may be imposed under Rule 14 for failure to comply with discovery obligations, and sanctions should be tailored appropriately to cure any injustice resulting from a party's non-compliance with its discovery obligations. So the real question before the court today is and really the only question before the court today is, has Ms. Reed suffered any prejudice based on blatant discovery and Brady violations by the Commonwealth? And the answer to that question is a resounding yes, she has.
Excellent. I'm really glad that the defense is fighting this. And if you've been following me, you are aware that I have accused the prosecution of multiple Brady violations in the Karen Reed case. Absolutely.
Ms. Reed, as the court knows, is on trial for her life, and she's been expending precious resources for some 3 years now, defending herself against provably false allegations. And at the center of that storm of defense are these sallyport videos. It should be pretty straightforward, really. I mean, it's just a series of videos at a particular location for a particular time. And that time is January 29th, 2022, from midnight until 11:59. It's a 24-hour period, 23 hours and 59 minutes. It should be pretty simple, but it has been anything but simple in this case. We've been asking for a full download of every single one of those cameras and all that footage from January 29th, 2022, from 12 a.m. to 11:59, but we've never gotten it.
When did you first seek it?
We asked for the preservation on February 2nd, 2022, when Mr. Yannetti said retain and maintain all physical evidence. We've been
Excellent. This is great. And Charlie Lynn 143. Charlie Lynn, I remember your comment. That was an excellent reminder, and I pinned Charlie Lynn's comment to my video. Charlie Lynn reminded all of us about that preservation order back in February of 2022, in which David Yannetti said that everything should be preserved rightfully, because if it wasn't going to be preserved, then we would have Brady violations. And Judge Beverly Cannoni agreed at that time. She agreed in February of 2022 to preserve, that the prosecution should preserve all that information.
Seeking these videos since well before the first trial. We didn't get them before the first trial.
Do you have a date? Do you have any chronology for me?
I don't. I can certainly provide those, but it's been...
I'd like that. I mean, that would be...
I'll be happy to do that. It's in discovery request after discovery request after discovery request. Basically, there's also a catch-all. We've been asking for all physical evidence concerning video footage from Canton PD from well before the trial. We didn't specify which cameras because we didn't know which cameras had video footage. We didn't know how many cameras there were, but we didn't get anything from the Commonwealth. And I'll address that in particular in just a second. Mr. Lally didn't give it to us before a full download, before the trial. The Commonwealth didn't provide it during trial. And today, as I stand here, we still don't have it. And interestingly, Mr. Brennan does make mention in his opposition that, quote, at no time has the defense ever made a formal preservation request. I found that interesting for two reasons, and I have two comments about that. First, as the court record reflects, on February 2nd, 2022, I just referred to it, Mr. Yannetti filed a preservation demand for, quote, all physical evidence to be maintained. That DVR, the footage on the DVR, is physical evidence that was required, not requested, but required to be maintained by the Commonwealth pursuant to that demand. But second, and this is probably more important, it wouldn't have mattered if we didn't ask for it to be maintained. It wouldn't have mattered if we didn't ask for it to be preserved. This was a self-executing duty by the Commonwealth. As Justice Gaziano stated in the same case, the Committee for Public Counsel, quote, a prosecutor's core duty is to administer justice fairly. To fulfill that duty, a prosecutor is required to turn over exculpatory evidence to a defendant without regard to its impact on the case. Failure to disclose evidence favorable to an accused that is material, either to guilt or to punishment, is a violation of due process. Litigation strategy plays no role in this process. Under our rules of professional conduct, a prosecutor is required to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate guilt of the accused or mitigate the offense. And he cites Massachusetts Rule of Professional Conduct 3.8 subsection D. The Commonwealth's Brady obligation is self-executing, Your Honor. It wouldn't have mattered one whit if we didn't ask for that footage, but it turns out that, in fact, Mr. Yannetti did ask that it be maintained.
Excellent arguments by Alan Jackson so far. He's saying that the law protects defendants in cases like this, that by default, prosecution teams are supposed to preserve all evidence. It's excellent, and that even if David Yannetti did not ask for a preservation order back in February of 2022, the prosecution knows damn well that they were supposed to preserve all of that evidence.
And the Commonwealth has still failed to preserve it. What we have gotten, it appears, are scraps and fragments of videos that the Commonwealth has decided on their own and within their own time frame to dole out to us over the course of months and years. And included in that scrap and fragment was a video that was missing 42 minutes. The court is well aware of this video. It was heavily litigated and heavily referenced at the first trial. That's the exact time frame. The missing portion is the exact time frame that the SUV was being pulled into the sallyport.
And that's not coincidence. You know, so much of what the prosecution tries to say about this case is coincidence. It is not coincidence that the moment Karen Reed's SUV is being pulled into the sallyport, all of that footage for 42 minutes is missing. Why does not the Canton PD or the MSP want us to see Karen Reed's SUV the moment it is entering the sallyport?
Video on April 4th, just days before the first trial. Keep in mind, it's a video from January 29th, 2022. Another one of those videos was the inverted video that has now seen some fame, that the Commonwealth tried to sell to the jury as a true and correct copy of a video within the sallyport, and we got that one after the trial started, in the middle of trial. So why were we getting videos from January 29th, 2022, 2.5 years later? And why were some of those videos altered or manipulated and not in their proper format? We still don't have answers to those questions. And
I'm saying, guys, like, the prosecution is shady as hell. You know, like, if you don't know anything about the Karen Reed case up until today is February 6th, 2025, even if you're just entering the Karen Reed case, listening to Alan Jackson's arguments here for the last 10 minutes, it's already really shady. Like, it's, you know, you don't even have to have the background knowledge of the Karen Reed case to know that everything Alan Jackson just stated is shady.
Literally, while we're asking that question and while we're pondering that question, a couple of days ago, we're getting yet more videos, scraps, piecemeal. We got another sallyport video just a few days ago. This one showing the Lexus backing into the sallyport from some exterior camera. And that also is exculpatory evidence. Mr. Brennan writes in his opposition that the idea that the defense has been misled or was misled in its efforts to try to go secure that DVR footage is a distortion of the facts with, quote, no legal merit. Really? A distortion of the facts with no legal merit? Where's all this footage coming from, if not the DVR? It's the only place it was held. It's the only place it was captured. So of course we were misled by continually getting these piecemeal snippets of footage from the DVR, from the very source, had to have come from there, coupled with the Commonwealth saying, and Mr. Brennan saying, yeah, come on out, you can have your expert come out, meet us at Canton, We'll provide the DVR. You can have him look at it. He can bring his equipment, download whatever you want from that 24-hour period. So what were we to believe? That it was on the DVR. It had to be. How else were we getting these piecemeal videos? And they've had that DVR for 3 years. They knew exactly what was and what was not on that DVR. They had to have. This has been the center of a storm that surrounded this case from the jump. And to claim otherwise, it's just patently absurd. So Mr. Brennan also wrote...
That's a great word to describe Hank Brennan and Adam Lally and McLaughlin and Michael Morrissey. They are all absurd.
In his opposition, that Mr. Jackson said, don't touch the DVR, don't mess with it. So I informed Chief Rafferty, tell your staff, don't touch it, don't mess with it, almost suggesting, intimating that it's my fault that we didn't know what was on the DVR. That's absurd also. How am I supposed to know what is or isn't on the Commonwealth's DVR?
Right, like, hello, it's the Commonwealth, it's the prosecution who are trying to prosecute Karen Reed, right? This is their case, right? The defense team's only job is to defend Karen Reed. It's not their job to have the Commonwealth's evidence, right? This is the Commonwealth's case. This is their evidence, and they somehow don't have it.
What I actually said, that was a sort of a liberal interpretation of the facts. What I actually said was, Mr. Brennan, do me a favor if we're going to come out there, just don't have anybody download it in advance. Let's do it all together when we're all in the same place. That's what I said, and he accommodated that. He said, sure, we'll agree to that. So based on this history of getting these small clips from January 29th, we knew there had to be more footage. So when Mr. Brennan came on board, we made the request to him as well as the requests that we had made to his predecessors. We want all the footage for that 24-hour period. And lo and behold, we started getting more clips, more snippets, more piecemeal bits and bytes from that DVR. And one of them was a clip of Brian Higgins standing out in front of Canton Police Department in the parking lot in the freezing cold at 1:35 in the morning on January 29th on his cell phone. To punctuate the importance of that video footage, recall that this issue was raised at trial. We talked extensively. When I say we, both the Commonwealth and the defense, me in particular, spoke with Mr. Higgins about this issue. It was raised at trial, and Brian Higgins never once, not once, on direct examination or on cross-examination, admitted to having made a phone call in the middle of the night on January 29th. And yet now, after the trial, we get a video of him doing exactly that. And that also proves that he lied in front of a federal jury, in front of a federal grand jury, when he testified that he didn't have or make any phone calls in the middle of the night. That is called exculpatory evidence, and that's Brady.
Excellent, excellent. I think Alan Jackson's about to say Brady violation, but excellent. Brian Higgins, we all knew he's a liar. We all knew that Brian Higgins was lying out of his ass. For all we know, he could have been the person to do this to John O'Keefe. We won't ever know because we weren't inside the house, but certainly Brian Higgins, Brian Albert, and Colin Albert, and maybe even Kevin Albert all know what happened to John O'Keefe, and Brian Higgins is now a proven liar.
Evidence, and it was withheld in its entirety during the first trial and for the last 3 years. And it's against that. The reason I bring that up, Your Honor, it's against that backdrop that we then say to Mr. Brennan, kindly give us the footage. I don't want this piecemeal thing to keep going on. Just give us the raw footage. We'll send an expert. So the plan was put in place, and experts were retained, and flights were booked, and hotels were reserved, and transportation was arranged, and all at Miss Reed's expense. She's writing the check for all of this. And our expert flies out to Canton, walks into the room, and within 10 minutes, they open up the front plate of the DVR, and lo and behold, Commonwealth says and agrees, oh goodness, there is no footage. It was overwritten within 30 days. What? How could that possibly be? So the expert calls me. Mr. Jackson, what do you want to do? And I said, I don't know. I'm not taking that's your job. I don't know what to do. If it's overwritten within 30 days, I don't know. Maybe there's a log. Let's find out who has access, whose digital fingerprints were on that DVR, who downloaded the footage, when it was downloaded. What about these clips that we have? I'm very confused. So the expert goes back and says to the technician for the Commonwealth, Colleen Crawford, well, let's at least download the log. At least we can have access to that and we can start unraveling what's going on here. Oh, sorry, that's been overwritten as well. There is no log. You get no footage, you get no log. This was a complete and utter waste of time.
And if you guys didn't watch my video with the defense's motion to recover expert expenses, it goes into this. It goes into the fact that there was no log, everything was overwritten, and Canton PD pretty much shrugged their shoulders at the expert who flew from Arizona to Massachusetts for nothing. And it cost Karen Reed over $12,000. I will leave that video in the description below if you're interested.
According to the Commonwealth, that system, as I said, overwrites every 30 days. So by February 28th, I counted them. By February 28th, 2022, every single frame of that footage should be gone. So how did we get the inverted video in April of 2024? How did we get the video clips of Brian Higgins in October of 2024? How is that possible? The only explanation, Your Honor, is that the Commonwealth downloaded the entire system within the first 30 days. Otherwise, it's gone, admittedly. And all of that has been withheld from us for 3 years. Then to add salt to that wound, the Commonwealth allows us to go on this wild goose chase, spend $12,000 some odd of Miss Reed's money, and fly an expert out to Canton for absolutely no reason. Zero. The 30-day overwrite protocol is something that their technician absolutely would have and should have and did know before we ever set foot in Canton. She was well aware of exactly why we were going out there. We were going out there to download footage from 3 years earlier. She knew it, we knew it, Mr. Brennan knew it, everybody knew it.
Yes, and Hank Brennan even responded opposing the defense's motion to recover expert expenses. And Hank Brennan agrees in his own opposition. Hank Brennan said he agreed to accommodate the defense team, right? Like, how are you going to agree to accommodate the defense team knowing they're sending out a guy from Arizona to Massachusetts and you know that there is no DVR footage for the expert to analyze? Like, I'm telling you guys, Hank Brennan is evil.
But within 10 minutes of walking in the door, it was revealed that there, in fact, was no footage. And that's a fact that the Commonwealth had to have been aware of for the last 3 years. Yet Karen Reed is the one having to foot the bill for what turned out to be just a snipe hunt. It's not fair, and the Commonwealth should reimburse her for this fool's errand that was not of our making, of her making. The Commonwealth has since told us, Mr. Brennan told us, that remarkably he went to Canton PD, and this is in his opposition paperwork in his declaration, and he spoke with some officer. And that officer told him that he, the officer, personally made a copy of the entire January 29th video footage and placed that copy in some sort of an iCloud account. Not on the DVR system, not in the official data bank in which it's supposed to be stored, but on some iCloud account. And we're finding out about this in 2025. It's outrageous. What it is this entire situation surrounding this DVR and the Commonwealth's maintenance of that DVR and the footage on it is a complete dumpster fire. And Ms. Reed has to pay for the fire extinguisher. And that's not fair. The High Court and the Committee for Public Counsel, the same case that I referenced a little bit earlier, and the court will know this because this was sort of the big takeaway from that case, is Justice Gaziano fashioned a cost-shifting remedy against the Commonwealth and for the defense. And that included the entire cost of investigating and locating and contacting nearly, I think it was 10,000 defendants. It was an enormous amount of money and an enormous undertaking. And the Commonwealth had to foot that entire bill. And the reason they had to foot the entire bill is because the Supreme Court decided that it was prosecutorial discovery violations and cost-shifting remedies were in order. We're asking absolutely no more than that from this court. Fairness dictates that Ms. Reed be reimbursed. And I'll submit, Your Honor.
All right, thank you very much. Mr. Brennan?
I get that Judge Bev is a Superior Court judge and she probably has like 10 cases a day that she has to preside on. And she's also corrupt, without question. But like, I'm just saying, if I were sitting in her seat, I would be looking at Karen Reed with shock, and horror. Shock and horror. Like, I am so sorry this happened to you. And I'd be looking at the prosecution with angry eyes, like I'm so disgusted by them. And I feel so bad for Karen Reed.
It's notable that the defense purposely conflates two very separate issues. If you had a chance to read their motion, they suggest that they should receive costs because they hired an expert, came to Canton, and didn't receive the information they wanted. Yet today in the argument, they try to give you a historical complaint about the production of videos in this case. That is a separate issue. That's a Rule 14 issue, but that is not the motion before the court. The reason I suggest they conflate the issues is because they know their merit for costs. I mean, their motion for costs has no merit whatsoever. And so what they're trying to do is incite facts, invoke this injustice they've created so that the court looks at the motion that they actually filed and gets it distorted. It is disappointing to stand before a court and file an affidavit as an attorney and have someone else have a cross affidavit. Frankly, in my career, when that has happened on rare occasions, I find that embarrassing. There is very skilled and able attorneys in this courtroom, and to work out discovery.
I'm so glad that cop car or ambulance is driving by the courthouse the moment that Hank Brennan is speaking. Like, he... Yes. Anyway, I just want to say, like, again, I will leave the video where I provide commentary about the defense's motion to recover expert expenses, as well as the prosecution's motion opposing the defense's motion, so that you have a better background about what Hank Brennan is arguing. And I will say, guys, I don't like Hank Brennan, as you all know. I think he's corrupt. I think he lacks integrity. And I do not think he deserves to be an attorney, because an attorney should have integrity and Hank Brennan has none. However, in the defense's motion to recover expert expenses, I'm saying this objectively, in the defense's motion to recover expert expenses, the defense does not bring up the February 2nd, 2022 preservation order. They did not mention that in their motion to recover expert expenses. They are bringing it up now. And generally, even though that should be widely known by the prosecution should already know that all the information, all of the evidence should have been preserved. Generally, when you file a motion, you are only permitted to argue on your declarations that you provided in your motion. So what I'm saying is Hank Brennan's argument here is that the defense is adding on arguments in court today that they did not argue in their motion to recover expert expenses. And actually, Hank Brennan is correct. But again, I'm saying that objectively. It doesn't mean that Hank Brennan is not corrupt. It doesn't mean that Hank Brennan is not a liar. I am just saying objectively, as someone who reads court documents all the time, someone who's very familiar with legal language and court documents, Hank Brennan is correct in this one instance. Otherwise, he's still an asshole.
Matters and agreements is something that attorneys always should do. And that is what I've tried to do in this case. I have tried to give the defense the best opportunity I can to get whatever information they want, whether it is required or not required. Yet, I'm standing here today, and I have to now share with you my conversations with the defense. I have to share with the court my position, which is contrary to the defense, because they have lodged a motion asking for money that they are not entitled to. If I stand back and do nothing...
I disagree. Just because Alan Jackson is adding arguments to the motion today in court that he did not provide in the motion doesn't mean that the defense team is not entitled to be recompensed for those expenses. It does not mean that Karen Reed is not entitled to be recompensed for the over $12,000 she spent because of what Hank Brennan agreed to accommodate. You see, I said this in previous videos. There is a civil issue here outside of everything that Alan Jackson argued. There is a civil issue here, and it's called detrimental reliance. Detrimental reliance because the defense relied on Hank Brennan's accommodations, expecting that their expert would be able to review the footage from Canton PD. And Hank Brennan was well aware, he's playing stupid now, but he was well aware the purposes for that expert of flying from Arizona to Massachusetts, right? Because the defense relied on Hank Brennan's accommodation, and that accommodation fell through, not because of what the defense team did, but because of what the Canton PD did, and because of what the Commonwealth did, because even the Commonwealth should have made sure that the Canton PD, even the prosecutors in this case, even the lead investigators in this case, even the Massachusetts State Police in this case, should have ensured that the Canton PD preserved that footage for the DVR expert to analyze. Okay? It's detrimental reliance because the defense team relied on Hank Brennan to follow through and he agreed to accommodate them. They are absolutely owed the over $12,000 that Karen Reed spent.
Remain the dignity of the court, then what happens is there are claims that just float out in nowhere, and a lie unchecked becomes the truth. So now I must stand before you and I must tell you what happened. When I entered this case in September and I began to look at discovery, I saw a video produced in August from the Canton Police Department, and we immediately turned it over to the defense. I began a study of the case and tried to articulate and account for all evidence and make sure the defense obtained everything that they were entitled to and more. The defense asked me to try to account for the video because they believed it had been an issue in this case. I looked through the docket. There was no motion to preserve videotape. I read the pleadings. Attorney Yannetti was meticulous in his motions to preserve. It was admirable. It was meticulous, the work he did. There was no motion to preserve, and that has some import. It doesn't relieve the government of their obligation to provide Rule 14 discovery or exculpatory evidence or Brady evidence. It doesn't relieve the Commonwealth of their obligations to be dutiful, but it is difference in kind. Because the defense, if they want something that is not obvious, they put the Commonwealth on notice. Having practiced for almost 3 decades, you file motions to preserve within 24 hours, 48 hours, or 30 days. And so when Mr. Jackson called me, Attorney Jackson called me, and he said he wanted to come out and bring an expert to look at the NVR or DVR of the Canton Police Department, I had never seen that in 30 years. It's not part of our obligations. He's not entitled to come into the Canton Police Department with his own experts and download his request. But in the spirit of transparency, in an effort to help the defense so there will be a fair trial and they can obtain all the discovery, understanding the history of this case, seeing that there was an August videotape post-trial, I wanted to do what
I feel like Alan Jackson is red right now, and he must be angry. And I would be too. And how he is containing himself, I don't know. But it's clear that Hank Brennan, again, has zero integrity. Like, the audacity. Like, again, he's admitting that he accommodated them. He's admitting that it's the Commonwealth's obligation. He's admitting that it's the prosecution's obligation to preserve everything, while he's simultaneously saying that there was no motion to preserve the data. There was no motion to preserve the evidence. Like, what's the point of even saying that? David Unetti stated that in open court in February of 2022, and Judge Bev responded. So it's on a court record. Judge Bev agreed, and it's on a court record. It doesn't need to be an emotion if it's on a court record, right? Like, it's documented. Maybe Judge Bev didn't specifically put it in an order, but it's on the court record. All they have to do is refer to the transcripts from February 2022. Right? Like, I'm saying, guys, like, Hank Brennan is overcomplicating this. He knows that his team fucked up.
I could to accommodate them. So without any hesitation, despite that there was no court order, no motion to preserve, I invited him to come to the Canton Police Department. I called the chief of police. I asked the chief of police, although this was unique and novel, unprecedented, could the defense come and access their material? Typically, the Commonwealth will download it and provide them a copy. She had no hesitation. So I called Attorney Jackson back, and I said that we would allow it. Attorney Jackson expressed concern, understandably, being a defense attorney, that almost 3 years later, the video may not be on the NVR. I had the same concern. I want all of the evidence. I'm not looking for evidence that's good for the Commonwealth or helpful for my case. I want all of the evidence. And so after he expressed the concern...
And that's not true, because Hank Brennan entered this case in September of 2024. And as of December of 2024, Jessica Hyde is only relying on Celebrite, right? Jessica Hyde is only relying on Celebrite because of what the prosecution, Hank Brennan, told her to do. So Hank Brennan is lying out of his ass. He's like, I'm not trying to be selective here about the evidence. I want all available evidence provided. Like, he's lying out of his ass. If that were true, then he would allow Jessica Hyde to use multiple tools when analyzing that 2:27 a.m. search. Okay, conveniently, Celebrite, the newer version of Celebrite, excludes the 2:27 a.m. search. And on top of that, Jessica Hyde, according to her own statements, is permitted to only rely on Celebrite because the prosecution told her to.
I made clear I had no idea what, if anything, was on the NVR. We could go and look at it, but Mr. Attorney Jackson didn't want that. He wanted his expert to be the person to open the NVR.
Yeah, and guys, Hank Brennan wrote this in his opposition to the defense's motion to recover expert expenses. Hank Brennan wrote that he offered to show the defense team what they have from the DVR, what the files the Commonwealth, the prosecution currently has from the DVR, and the defense team declined, right? But like, it's the defense's right. It's the defense team's right to go after the original data, the original files, which should have been saved in the DVR system. Okay? anybody looking at this case and knowing full well how corrupt the prosecution is would not want to rely on any evidence the prosecution has in their possession, because we all know that the prosecution is lying. They've withheld evidence. They've committed multiple Brady violations. Of course, the defense does not want evidence that the prosecution is holding on to. They want the original data, the original files, right? Because any of the evidence that the prosecution has could be altered, could be doctored, right? Again, if we left it up to the prosecution to determine whether or not that 2:27 a.m. search happened, to the prosecution, it never happened. But to real forensic science, it actually fucking happened, right? So what I'm saying is, I do not fault the defense team for not trusting the prosecution's evidence. They want to see the evidence themselves. They want to go to the source, and that is within their right. And it was absolutely Canton PD's responsibility to still have that evidence. You know, as a police department, it's absolutely their responsibility to record shit, you know, to save things. Like police departments never save anything. It's such bullshit.
And respecting his position, providing a professional courtesy, I agreed. Didn't mislead him. I didn't think there would be video. I had no idea. So Mr. Jackson, Attorney Jackson, pardon me, sent out his expert. And by the way, the expert that came was not the expert they designated. I got a call because we were in court on a hearing that they had sent a different expert they hadn't noticed. And my response was, it doesn't matter. Whoever they send, let them look at it. And so when they did,
like, what's the point? What's the point of emphasizing that, Hank Brennan? Like, are you virtue signaling? Like, see, Your Honor, I was so helpful. I didn't even care that they switched their expert at the last minute. Like, he's giving himself brownie points. Like, so desperate this man is, you know? If he would just for once own his own bullshit.
surprisingly, the information had been overwritten. Now, while there was a 30-day override on that machine, I believe the defense expert knows that there was a backup hard drive which kept materials longer than that 30 days. I do know that there was materials on that DVR, NVR, back in July of 2000.
I love Karen Reed. I don't know if you saw Karen Reed looking at Hank Brennan and then looking back at her family and smirking. Like, I love it because we all know that Hank Brennan is very sensitive to facial expressions, especially facial expressions coming from women.
24, and I know that from a report that was generated by the Commonwealth and given to the defense, so they should know that as well. That may be one reason why they wanted to come out. They came out on their own volition. I extended the courtesy as much as I could, made no promises. I was clear, I was very uncertain about what would be on there since I never looked at it. After I learned there was no information on the NVR, I took the initiative and went to the police department. I viewed the police department, the cameras, I spoke to personnel, and I spoke to the retired individual who then was responsible for providing video upon request. And when I spoke to him, he told me in conversation that he would routinely store a copy on a file he noted as a detective file or on his hard drive. That was news to me. I thought that was helpful, so I notified the defense about my conversation. I was not trying to lure them back to Canton or have them spend money. I was trying to, as I always do, be as transparent as I could and as helpful as I could. Now,
as I always do. Hank Brennan, that is not what you always do, and everyone paying attention to this case knows it. It is not what you always do.
what I simply should have done and could have done is I could have gone to that detective file and downloaded the video and given a copy to the defense. That's my obligation, no more. But I didn't. I extended the courtesy that if they wanted to come and look at that file before we opened it, so it could be beyond reproach, they were invited to do that. I wasn't encouraging or luring them. I was inviting them. Because
It's insane, right? Because the defense's own expert, I do not remember his name. I'm trying to remember, but I don't want to botch it. But again, I will leave the link to my commentary video about the defense's motion to recover expert expenses. I'll leave that video in the description below so that this all makes better sense to you. In that affidavit, and the expert's affidavit, the DVR expert, he says that he asked if there was a backup. He asked the Canton PD, the technician, if there was a backup, and they said no. Like, they had nothing for the dude to review. It wasn't in the DVR system, it wasn't saved on a hard drive. They didn't have shit for him, even though he came all the way from Arizona. So it's crazy that that the Canton PD they won't cooperate with the defense team, but they will cooperate with Hank Brennan. Do you guys see? The Canton PD to this day is cooperating with the prosecution, but they will not cooperate with the defense team. You guys see that? Crazy. Again, the Canton PD is still corrupt. Everybody in Canton, should be worried for their life. Don't ever get caught up with the Canton PD if you're living in Canton, because they are not on the right side.
Been part of the process. I thought it would be disingenuous not to let them participate. And what they told me is to wait. So now that information, whatever it is, I don't know because I haven't seen it. And I've asked the detective or the retired detective not to access it. It is sitting in that file, supposedly. So at this point, it's the Commonwealth's position that we are going to go and download that information and give a copy to the defense. The defense waited almost 3 years. The defense was very clear about my uncertainty would be on that tape. And now they stand before the court and they try to parlay this into some type of injustice for their cause. The case they cite, Commonwealth v. Frith, the district court was overruled in assessing costs because there was no egregious violation. This is not a Brady case. This is not a setup. This is the government providing information as the case progresses and evolves and changes and retools. So what we have now is information.
Hank Brennan, again, just full of shit. No, it's the Canton PD voluntarily not cooperating, deliberately not cooperating with the defense team. They have no information for the defense's expert when he arrives at the Canton PD all the way from Arizona, no information for him. But suddenly they have information for Hank Brennan, right? For Hank Brennan to describe this as if it's not a cover-up, it's just wrong. It's incorrect. And again, he has zero integrity.
Supposedly on a database that we are going to get and give to the defense. You should deny their motion. Nobody was misled in this case. They've taken a professional courtesy in an effort to help, and they've distorted it into some type of injustice. The Commonwealth's not going to be distracted from the cause in this case, which is a trial on April 1st. The court should not be distracted from the cause in this case. If they have a separate motion about Rule 14 violations, or motion dismissed for misconduct, that's a separate motion. That's not the motion before the court today. The motion before the court today is to attempt to recover costs for something they chose to do and that I accommodated. It should be rejected. Thank you.
Okay. Any quick response, Mr. Jackson?
Very briefly, with the court's permission. By the way, it is a Brady case. There's no question that the data on those videos are Brady. They're exculpatory. That's where we start. So Mr. Brennan can say all day long, that's not a Brady case, don't worry about it, let's just sweep this under the carpet like we've done everything else. There's nothing to see here. That's not true. It's a Brady case because the information that we have now received from that DVR, that NVR system, is exculpatory to Ms. Reed. That's why I cited
Brian Higgins part?
That's why I cited the Brian Higgins part. Correct. And I suspect there's a lot more on there as well. The inverted video part is also Brady, which we got in the middle of trial. Mr. Brennan says, basically, his argument is, deny the motion because they took a courtesy. I'm trying to be courteous. And he's a gentleman. This is not personal to Mr. Brennan. He seems to, the tone of his responses was, well, this is personal between Mr. Jackson and Mr. Brennan. It's not personal at all. This is about the defense and the Commonwealth. It's about Ms. Reed and the Commonwealth. But let's not conflate a courtesy with an obligation. The Commonwealth has an obligation. I don't care that Mr. Brennan wasn't on the case previously for the last 2.5, 3 years. It doesn't matter to me. This is not personal to him.
Exactly. It doesn't matter if Hank Brennan just came on September of 2024. Does not matter. Adam Lally was there the whole time, and he is still there today.
I appreciate the fact that when he came onto the case, he immediately found in August, he found a video that had never been turned over. I can't fault him for that. He turned it over when he found it, apparently. What I can fault is the Commonwealth. Mr. Brennan was brought onto this case not to represent Mr. Brennan, but to represent the Commonwealth. And all the foibles, all the warts and blemishes that preceded him, unfortunately, are now his responsibility as lead counsel for the Commonwealth.
Excellent. Brilliant. I love Alan Jackson. I always will. He's excellent.
Well, he indicates that when he found out that we wanted to come look at the DVR, and we had absolutely no right to look at that DVR, this was just a courtesy, etc. Well, that might be true if we hadn't made the request, because we had been getting piecemeal videos from a DVR system that it supposedly was overwritten.
So the oral request by phone call you're talking about?
The latest one, right. To my request to come out and have an expert come out and see it. That's not just a courtesy. That's just good lawyering on his part and mine. You want to keep your hands clean, let's do it the transparent way. Have everybody come, bring their experts, whoever they might be, and let's download this stuff together. So there's no funny business, and everybody can wipe their hands and say, I didn't have anything to do with it except downloading the material, and whatever that material is, it is. That's just good lawyering. It's not a courtesy. He was doing that to protect his own and the Commonwealth's interests, and it was quite smart. Until he realized, because he didn't have any way of knowing it any more than I did, that there was no footage. It had been overwritten. Perhaps, certainly the defense was deceived. Perhaps Mr. Brennan was deceived as well. He indicates that he contacted Chief Rafferty, and she said, with no hesitation, yeah, bring him on out here. I wonder if that lack of hesitation had anything to do with the fact that the chief knew there was no data on the DVR. You come look all you want to. The bucket's empty. I have no idea about this iCloud account, or who owns the iCloud account, why this data on January 29th was moved from the DVR to the iCloud account. Mr. Brennan did say, do you want to have your expert come back out and watch as we download the iCloud account? And I said, let's defer that, because this is literally, these are the contours of motion that's going to be before the court. And I still want to defer it, because what I didn't want to do is pay another $12,000 or $15,000 for a second bite at this apple, just to find out that iCloud account is somehow compromised as well.
Can you have someone record it? Can you have somebody that it won't cost you $12,000 if you want to come out and just have someone record it as it's being done?
Sure, I didn't mean to interrupt the court. Yes, I can certainly make accommodations other than flying an expert out and having somebody do it in person. That may be an option that we exercise. I may talk to Mr. Brennan about that, because I still want to have some transparency on that process. But what I don't want is to throw good money after bad at this issue when she's already spent $12,000, $12,200 and something dollars for absolutely nothing. This is not a matter of courtesy. This is a matter of obligation. This was a matter of Brady. It's no different. And by the way, the case that Mr. Brennan cites, he indicated that I cited that case. I didn't cite that case. Justice Gaziano cited that case in his opinion in the committee case. And the ultimate opinion of that court was when there is a discovery violation, when there is a Brady violation, and there is no question that that's what's before this court. Blatant discovery and Brady violations. The Commonwealth doesn't, the court may remember, by the way, on the witness stand when these videos were coming in piecemeal, especially the inverted video, 2 or 3 witnesses all went like this. I wasn't the one told it. I wasn't the one that downloaded it. Buchanan. I wasn't the one that downloaded it. I don't know where it came from. It just ended up on my desk on a flash drive. I don't know where it came from. Everybody was pointing fingers at everybody else. Nobody could establish a single chain of custody for those videos, and we still don't have it. So
Excellent. And if Judge Bev wants to prove that she's a good judge, because we all know she's corrupt, but if she wants to prove that she's a good judge, she will get on the Commonwealth. She will get on the prosecution for failing to have a chain of custody for virtually everything.
Chief Rafferty's statement, yeah, come on out, no hesitation whatsoever. They can come look at it. I suspect it's because she knew it wasn't there. This was we were led in a circular runaround, and it was ultimately at her cost, and that's what.
So didn't the two of you, when you talk about good lawyering, didn't both of you agree that it was highly unlikely it would still be there? Or are you saying that part's not true? Mr. Brennan told me that.
I said, I'm concerned if we don't get out there fast. I don't know what the override protocol might be. So yes, I was concerned, but who cares? Well, that's no legal moment. What I thought, what Mr. Brennan and I discussed 3 years after the fact, when the Commonwealth has a self-executing obligation to provide that information to us because it's Brady. They also had an obligation pursuant to Mr. Yannetti's demand, not request, but demand to maintain that information.
So where is that demand? Is that in the file? Where is that demand?
February 2nd. I don't know what the docket number is. It was filed on February 2nd after arraignment.
Here?
Wherever the arraignment was, Mr. Yannetti.
It was in the Stoughton District Court.
Okay.
But it's part of the case file. And it stays with the Commonwealth, and that obligation stays with the Commonwealth. But I would propose to the court that even if the court's concern is, well, when was that filed, and did Mr. Brennan
I haven't seen it. I know it's not part of our file, and you're talking about it as if it were here.
Your Honor, I can't say with certainty, but I believe that it may have been submitted as an exhibit to a previous motion, probably early on in this case.
Okay, I just wanted our record to be clear.
Of
You're
course.
talking about Mr. Yannetti filed this. You did not file it in this court.
I may have filed it as an exhibit.
Attachment, but it was
but
never
not-
any.
Right. There was, I don't mean to cut off the court, Judge.
It was never brought before me or a judge who had this case before me to be heard.
So there was early on, and so many motions have been filed in this case, but early on I did bring a motion, I believe before Your Honor, asking that all of the Stoughton District Court motions that I had filed at arraignment and thereafter be ratified by this court. That is in our record.
So I need you to find that.
Happy to do it.
And tell us when it was filed, the act. I need to see that.
By the end of the day today, you will have whatever submissions we provided, and if it's not part of an exhibit, you will have that motion.
All right. Go ahead,
Just
Mr. Chair.
to answer that one question that I can't answer because I've seen the filing. It was filed February 2nd, 2022, court stamped. My point is, even if that weren't the case, and it is the case, the obligation is self-executing. That's what Justice Gaziano was talking about when he talks about in the committee case, the self-executing duty that a prosecution has or a prosecutor has to maintain and preserve exculpatory information and provide that information to the defense. They didn't do that, and they led us to believe every single sign and signal, irrespective of what Mr. Brennan did or didn't actually personally know. The Commonwealth's conduct in this case, from the beginning of the investigation to now, suggested that information existed, the DVR existed, the video footage on the DVR existed, and we were going out there to download. We shouldn't have had to jump through this hoop and go on this wild goose chase at Miss Reed's expense. It is not, I think we can all in this courtroom agree, none of this is our fault. We didn't do any of this. It's all on the Commonwealth's shoulders. It's all their responsibility. They should have to pay for what happened when we went out there for absolutely no good reason. And I'll submit.
Mr. Brennan, I have just a couple of questions.
Yes.
So you don't know for certain whether this information was in fact downloaded onto the hard drive, but you suspect it is based on your conversation with the named gentleman in your affidavit?
So there's two different systems. One's called the DVR, NVR. That's the actual system that keeps all the footage that's recorded. That has been searched.
Commonly is overridden every
Yes.
30 days.
Like has been overwritten.
Statewide police departments.
Yes, Your Honor. And
Okay.
that has been overwritten.
Okay.
And there is no information on that.
Okay.
When I spoke to the retired sergeant detective who had downloaded video, he said as a habit, he would routinely, when he would make a video copy from the DVR, he would place it in a separate file. I can't say that it's exhaustive. I can't say that it captures all of the video. It's when he would make a copy, and it seems in this case there were select copies made. It doesn't seem that there was ever a time when somebody just copied the entire event. Now, the issue of whether there was a request for it, the obligation of the Commonwealth, I think is a separate issue. What exists on his hard drive in the detective file, I don't know. But what he has told me is he would routinely make copies of what he would provide to the court in the Commonwealth, but the Commonwealth in defense, and he would.
It's really interesting that we keep hearing the sirens during Hank Brennan's arguments. Just not while Alan Jackson is arguing, but during Hank Brennan's arguments. But I want to say Judge Bev's question earlier to Alan Jackson as to whether Alan Jackson and Hank Brennan actually had that conversation about both of them agreeing that it may not still be in the DVR system, the footage may not still be in the DVR system, and that both Hank Brennan and Alan Jackson were in agreement about that. They were both doubtful. They were both worried. And when he's questioned about it by Judge Bev, Alan Jackson says it doesn't matter because it's still their obligation. I just want to say from a legal standpoint, it does matter because it implies that Alan Jackson, the defense team, knew that there was a possibility that the footage would no longer be on the DVR system. So I get why Judge Bev asked that question. Ultimately, I side with the defense because I do believe that Hank Brennan did this on purpose. I believe the prosecution committed yet more financial abuse against Karen Reed by having the expert fly out to Massachusetts from Arizona for nothing, and it cost Karen Reed over $12,000. Okay, I do think that Karen Reed should absolutely recoup those expenses. However, that legally, objectively, if Alan Jackson knew that there was a possibility that there would not be footage on the DVR system, then Alan Jackson should have had someone who was already in Massachusetts, like go to Canton PD just to make sure that the expert from Arizona wasn't going to have a futile trip that would result in nothing, And again, I'm speaking objectively. I get that some people don't like me playing devil's advocate here, but, I'm biased most of the time. I am all Karen Reed, okay? I am so free Karen Reed here. It's not funny. Again, I live in Massachusetts. This case hits close to home for me. It's in my backyard, okay? I got involved providing commentary about this case because to me it's personal. I take it personally. But I can still be objective, and I am telling you guys, there's a reason Judge Bev asked Alan Jackson that question, and his answer that it doesn't matter, I could see it being held against him just a little bit. Ultimately, he's correct. It doesn't matter. It should have been preserved by the prosecution 1000%. All of the footage from January 29 should have been preserved. Absolutely. But again, if Alan Jackson was aware that it may not still be in the DVR system, he should have had someone in Massachusetts verify that before sending the expert out from Arizona.
Put on that separate file. I don't expect, and I'm only guessing, that it's going to be an exhaustive copy of the entire night of January 29, 2022. I don't expect that. I expect it will be a copy of whatever it is that he has provided in this case. And so I think before it goes there forever, it should be copied and it should be provided to the defense.
All right. So I do want you and Mr. Jackson to talk about whether within the next week you do have somebody video it, or at your expense you send somebody out at it, but let's get moving with that. I know you said you'd download a copy and send it. Are you satisfied with that, Mr. Jackson, or do you want to have someone there while that occurs?
I at least want to noodle on that for a second, but I'll talk to Mr. Brennan about it.
All right. I'd like it done within the week. The person has to be there within next week, or the Commonwealth will download it. We've got to get this case moving, and you want it, so it's got to be provided.
The stall isn't my fault. Yes, we want it. That's why we asked for it in the first place.
So let's try and work it out before you leave here today, okay?
Sure.
I'm happy to defer the defendant's request. I'm prepared to do it now. If they want me to wait, if they want to have somebody there, I'm receptive. But we're ready to do it now.
All right, so I'm telling you to please wait, work it out, but no later than next week.
I understand.
All right, thank you. Did you want to be heard further? In
Briefly,
response?
Your Honor, although I've come into this case late, I am the Commonwealth, and I assume all responsibilities of the government's case in the history of it. This motion is not about a Rule 14 complaint or a violation. If the defense has a motion to sanctions or to dismiss, or whatever the remedy is, because they think they've been agreed, that would be a different motion. This motion is they're trying to get the court, or asking the court to impose costs because they had their expert come out at their request, and they were very clear about the risk associated with that. This motion should be denied. If there's a separate motion, we'll deal with that when it's filed. If I had known that the defense was going to argue something entirely different, and that is the failure to preserve, I would have made a copy of all Mr. Iannetti's motions and requests, and I would have provided them as an exhibit. But I did not do that because that was not the scope of this motion. This motion should be denied.
All right, thank you very much. Taking this under advisement. And do not wait for a decision from me on this about whether or not you send somebody out to get that video.
We'll get started on that immediately.
All right. So let's move on to the Commonwealth's motion for clarification regarding the search warrant or the contents of the defendant's.
So if you guys didn't catch that, Judge Bev is not making a decision yet as to whether the Commonwealth should pay Karen Reed back for the over $12,000 she spent to have the expert fly out from Arizona. The judge, Judge Bev, is, quote, taking it under advisement.
Or more accurately. Please.
In reviewing the discovery in this case, I learned that there was a search warrant for Miss Reed's phone. That search warrant entitled the Commonwealth to search for data that's outlined in what's known as addendum or attached as addendum A. Learning the history of this case, I further learned that because there was an assertion of privileged communications, there was an agreement that the Attorney General's office would look through the data on the communications, and they would identify any attorney-client privilege information, extract it, and then provide the information back to the government and the defense. I am not sure of the accuracy, but I learned or read that the defense was given an entire data copy, forensic download of Ms. Reed's phone years ago. When I looked through the discovery, it surprised me that the Commonwealth did not receive the forensic data. It received a report. And when we reviewed the reports, it had references to navigation information and Google searches, but did not have any of the forensic download. And so clearly, the Commonwealth has a warrant, is entitled not only to the PDF extraction, they're entitled to the full force of that proof, which is the data. I spoke to my experts, and they advised that they believed that the data would have more information than simply a PDF. And so when I learned this, I wanted to both scrupulously protect the defendant's rights, but I also wanted the data for our review. And so I limited my request for the data to navigation information in the Google searches. Although I do not believe it was required pursuant to the communication protocol, I asked the Attorney General's office to engage in that protocol anyways, just out of abundance of caution and respect for the defense. I contacted the defense. The defense offered their objection. I think it has no legal merit whatsoever. They don't have standing at this point, but I noted their objection. I believe, without certainty, that the Attorney General's office has gone through that review to make sure there are no communications. However, they expressed some reluctance to provide the information because of the existence of the communication protocol, and they did not believe there was enough clarity that there was a distinction between navigation information. I do not see that navigation information, Google information, or the other data that I want is covered by the protocol. I believe that protocol has at least partially already been followed anyways. Time is of the essence. This case is on for April 1st. There is what I believe to be relevant material, important information, including Google information and navigation information that we are entitled to. I don't want delay. So I filed this notice so that the court could give direction, either assuring the Attorney General's office that they could provide the information, or if there is going to be a protocol, which I discourage, that it's expedited. If there is something the defense wants to look at prior to me receiving it, it should be on a very, very narrow time frame. I don't think they have a right or entitlement to review anything I get. I think the Commonwealth is entitled pursuant to the search warrant. If they have a remedy, it's after we've already reviewed it, not before. And so I'm doing this to facilitate things because I'm mindful of the April 1st file, and we will pursue this information and use it if relevant.
Okay. Is there an opposition? I don't have anything in writing.
Your Honor, not really. The only thing that we expressed to Mr. Brennan was, and maybe I misunderstood his first, there was a communication that we had on the phone. I thought that he was seeking something far broader than the search warrant. It sounds like he's staying within the parameters.
It sounds squarely within the search warrant.
So that doesn't bother me. I want to make sure that whatever information he gets is squarely, as the court just said, squarely within those parameters. January 28th at 9:30 p.m. until January 29th at 5:30 p.m. And otherwise, I don't disagree that students in the search warrant can get the. I'm calling it raw data, but I think we all know what we're talking about. Not the PDF, but the underlying data.
All right, it's squarely within the search warrant.
Right.
I do feel Mr. Brennan did not have to come to me or even you with it, but I do appreciate that you did so. So yes, so the AG's office knows that you are entitled to that information. You may have it immediately.
Thank you.
Okay. All right. So the motion regarding, just want to get Commonwealth's motion for reciprocal discovery pertaining to employees.
I didn't really have a comment about that because that was a separate motion. It was the prosecution's motion for clarification. And if you're interested in that motion, I'll provide a link to the court document, the motion in the description below. To me, it's neither here nor there, really. It's just the AG's office and the prosecution corresponding and coordinating to get Karen Reed's cell phone searches and whatnot from the time frame before John O'Keefe was murdered and shortly after he was murdered. And I doubt they're going to find anything, so I'm not worried about it, and it looks like the defense is not worried about it either.
ARCA, and then if you go one step further than that, are we going one step further than that with the second motion today, or do counsel want to come to sidebar and tell me any information you have, or how do you want to do this?
Whatever the court's most comfortable with. An open court or sidebar.
I'd prefer to find out what's going on over in federal court at sidebar first.
Yes, Your Honor.
So if you guys didn't hear, Judge Bev is talking about the motion from the prosecution, from the Commonwealth, to exclude the ARCA experts. And there is a federal issue here at hand because, again, the FBI hired the ARCA experts to investigate John O'Keefe's death. There's also speculation that the FBI hired the ARCA experts to combat Michael Morrissey because Michael Morrissey apparently hasn't been cooperative with the FBI. But again, that's all speculation, rumors. We just have to see how this all turns out, you know. But there's no denying that the FBI did conduct their own investigation of John O'Keefe's death. So if that tells you anything, guys, the FBI didn't leave it up to the Canton PD. The FBI did not leave it up to the Massachusetts State Police, right? That should tell us everything.
All right, so I will hear you, Mr. Brennan, on your motion for reciprocal discovery.
Your Honor, we're expecting to file a certificate of compliance this morning. We've provided voluminous discovery to the defense, and it is now incumbent upon the defense to reciprocate pursuant to the rules. I filed a motion to reciprocate. Also, there is a specific motion regarding expert witnesses relative to so-called ARCA experts. Those requests are consistent with information that we routinely provide pursuant to Rule 14, and we are asking that the defense comply if they expect to call these witnesses at trial.
And you have specific requests for the discovery, right?
I do.
All right. Mr. Jackson?
Thank you, Your Honor. I appreciate the opportunity to be heard on that. I appreciate Mr. Brennan's indication that he intends to file the certificate of compliance today. We know what our obligations are under Rule 14, and we intend to comply.
Okay. All right, so the motion is allowed. And Mr. Jackson, you had a scheduling concern?
I do. Concerning we received notice of discovery number 58 last night. I'm guessing it contains between a dozen, maybe 15 categories of new information that we're getting within that notice of discovery. They're substantial, including multiple experts, some individuals that we've never seen anything from. I believe that upon review and analysis, some or all of that will be relevant to our motion to dismiss, which I think is going to be pretty full-throated. The court indicated that it wanted us to file our motion to dismiss, I think, by the 11th, which is in 6 days from now. I don't think that's a reasonable possibility. We simply cannot get it done that quickly. I would ask the court, urge the court to allow us until sometime the beginning of March. We've got several dates on calendar. I don't have them committed to memory, but we'll be back at the beginning of March. That motion to dismiss, I think, if we have the time to do it and get it filed by the beginning of March, it's not going to take an enormous amount of court time. The time that's going to be taken is our preparation of the motion. But actually arguing it and ultimately the court either taking it under advisement or deciding on it, I don't think is going to be that burdensome. Although it's going to be a very, very full-throated motion.
All right, so you first raised the issue, I believe, in a footnote on one of your other motions that was filed, I don't know, January 21st or earlier, that this motion to dismiss is coming. You had a motion to dismiss it, the last trial, the same thing, forecasted, and then it's coming. I need that motion in order to get it heard before then. Let me hear what the Commonwealth has to say. What's the extent of the information that you provided today or yesterday?
In the most recent discovery?
Yes.
It was voluminous.
Okay.
We provided a number of expert witnesses, entire files of expert witnesses. We've been providing discovery in an ongoing manner rather than wait until the end. When I've retained an expert, we've notified the defense. When we have reports, we've notified the defense and provided them almost immediately. But there is quite a bit of information that we put together regarding expert reports and data information, accident reconstruction, phone investigations. So we sent it by link because it was extraordinarily large.
Okay. Does the defense anticipate evidentiary motions in this case? Got time that maybe I can flip these. Do you anticipate evidentiary motions?
Can I just... I don't anticipate evidentiary motions from our end. Obviously, if that changes, I'll let the court and counsel know immediately, but I don't think so.
How about the Commonwealth?
There are none expected.
Mr. Jackson, I'll give you until February 20th to file that motion to dismiss. And we'll hear it. If there are no evidentiary Commonwealth, I'd like you to comply with your response, if you could, by the 27th, 28th. Oh, wait, this is March. I'm sorry. No, February 20th. Yes, if you could have it by the 27th, please. And then we will have a hearing on it on March 4th. If there are any evidentiary motions, they must be filed by February 11th. And I want you to talk about whether we have a voir dire of the defendant's proposed witnesses, because we'll have to do both at the same time.
Your Honor,
Right.
is it possible, I'm just looking at the calendar for the first time as the court's going through its calendar. Is it possible that I could urge the court to allow us 24th to file the motion to dismiss? That gives us a weekend. That is incredibly meaningful for us. I don't want to hamstring the Commonwealth if they need until the 3rd to give them a weekend. Possible?
But also, I need weekends.
Right.
So it's not possible. So I'm giving you from February 11th to February 20th. I'll give you to the 21st.
Okay, 21st. Thank you, Your Honor.
Commonwealth, I'll give you to the 28th. Okay?
Thank you.
All right.
So, Judge, are we taking off 218?
We're going to take 2-8. Let's keep it on now.
Okay.
If you work out if you believe that it would be helpful after talking to do a voir dire of those witnesses, we've got the 18th free.
The 18th of
February. You were supposed to be here anyway on your motion to dismiss.
Okay, I'll discuss it with Mr. Brennan.
All right. Thank you all.
Your Honor, may I?
Yes, I'm sorry.
A few things, housekeeping matters. One, I'd like to set a date for reciprocal discovery. There has been no date
Yes.
sent. I'd like to...
All right, so you were filing your notice of compliance today. Do you have it now to file?
I do. Can I just show
Okay.
it to the defense?
Sure.
Oh, it's an extra copy? Okay. Yeah, this one if you want it. Awesome. Thank you. May I hand this in, Your Honor?
Thank you.
Thank you, sir.
All right. So all reciprocal discovery be provided by March 6th. All right, thank you all.
One last.
Yes, I'm sorry.
Could we come sidebar for this?
Sure.
So to add on to what Judge Bev just said, the defense has just 2 weeks to file their motion to dismiss. Today is February 6th, and the judge is giving them until February 21. She originally said February 20th, and then she added an extra day for them. So 15 days from today, that motion has to be in. That puts a lot of stress on the defense if they're trying to have a thorough motion to dismiss. But notice that the prosecution gets an additional week. You know, they get to receive the motion to dismiss, and then they get a week to respond to the motion. And this, obviously, if you aren't aware, this will not be the first motion to dismiss that the defense filed with Judge Beverly Cannoni. She dismissed all the prior motions to dismiss. She denied all the prior motions to dismiss. So this will be yet another motion to dismiss. And to me, the defense had great arguments to have this case dismissed previously, multiple times, but multiple times Judge Bev denied those motions. And I have a feeling she's going to deny this one as well. You know, she doesn't care that the defense has just 2 weeks to put it all together.
Mr. Brennan, anything else?
Thank you very much, Your Honor.
Mr. Jackson, anything?
No, Your Honor, thank you.
All right, thank you all.
Court, all rise, please.
And that concludes today's motion hearing in the Karen Reed case. Thank you all for being here. And again, I will leave the links to those motions and to the commentary video in the description below. Thank you for watching.